Welcome to the Law of Contract 2 course at the University of the West Indies Faculty of Law, Caveville campus. In this semester, we will look at 6 different topics. First, mistake, then misrepresentation, then illegality, breach of contract, frustration, and lastly, remedies. Today's lecture is on the area of mistake. What we will do is I will give you a brief introduction to the doctrine of mistake and then move on to discuss each of the 4 types of mistake. And lastly, I will summarize all the various types of mistake and the cases involved. Now, in terms of an introduction to the doctrine of mistake, there's a very instructive case that we can look at, which is Leaf and International Galleries. From this case, we will discern that not all mistakes that we would commonly see in everyday life are the types of mistakes that would lead a court to undo a contract. In fact, only very few types of mistake would qualify a litigant to have a contract voided by the court, and that area is very restrictive. Now, Leaf is an instructive case for this, because Leaf is a case where everyone would agree that a mistake was made, and in fact both parties made the same mistake, and so it might follow that the contract that resulted from that mistake should be voided, but it was not. Now, what happened in Leaf was that a buyer bought a painting, and the painting was of a cathedral, Salisbury Cathedral, and both the buyer and the seller genuinely believed that the painting was by a particular painter called Constable. It turned out many years later that the painting was not painted by Constable. And at that point, the buyer wanted to reclaim some of the money, because obviously if you're buying a painting from a famous painter, you'd expect it to be more expensive than if it was from another painter. However, the court said that although both parties had made a mistake as to who painted the painting, this was not the kind of mistake that would qualify for a mistake in law and a mistake that can lead to the contract being voided altogether. In other words, the contract stood. In the words of Lord Denning, this was a contract for the sale of goods. There was a mistake about the quality of the subject matter because both parties believed the picture to be a constable. And that mistake was in one sense essential and fundamental. But such a mistake does not avoid the contract. There was no mistake at all about the subject matter of the sale. It was a specific picture, the Salisbury Cathedral. The parties were agreed in the same terms on the same subject matter, and that is sufficient to make a contract. So in other words, what Lord Denning is saying is that at the time of contracting, there was a meeting of the minds between the two parties for the sale of this particular painting. And of course, whether the painting is of a cathedral, or whether it's painted by a constable, or whether it's of a certain size, all of these points may be important. However, what the court asks is, what is the subject matter of the transaction? And in this case, Denning found that the subject matter was for the sale of a painting. And obviously, the seller sold the painting, the buyer got the painting, the seller got the money. So everything happened just as it was planned, so long as we agree that the subject matter was the sale of a painting. So there was nothing wrong, and the court did not set aside the contract. As we will see, this is an example of a common mistake. And it's a good case to illustrate that mistakes in law, the ones that qualify for setting a contract aside, are quite rare, and it's very difficult to have a court void a contract on the basis of mistake. The courts are very restrictive in this way. And the reason they are restrictive, or one of the reasons, is that the effects of voiding a contract basically mean that the contract is voided ab initio. That means from the point in time when the contract was first formed. Now in Leaf, the case was brought 5 years after the transaction. Now, within those 5 years, a lot of stuff can happen. For instance, the original buyer may have sold the painting on to someone else, and that person may have sold it on to someone else, and so on and so forth. So if the court were to set aside the initial contract, then all these other buyers would be adversely affected, and there would be a myriad of consequences. So this is one of the reasons why the courts are very reluctant in voiding contracts on the basis of a mistake. Now, the 4 types of mistake there are common mistake, that's the one we're going to discuss first. There's mutual mistake, there's unilateral mistake, and then there's a 4th category, which is documents mistakenly signed. So all of those 4 types of mistake fall under the heading of doctrine of mistake, and as you will see, within each of those types of mistake there may be further subcategories. Now let's begin with common mistake. Common mistake is basically a shared mistake. That means the parties make the same mistake. So as we just saw in the case of Leaf and International Galleries, both parties believed the painting to be a constable. That was a mistaken belief, but they both shared that mistaken belief. Hence, it is a common mistake. Now, within the category of common mistake, there are 3 types of common mistake that we can distinguish. 2 of them are fairly simple, fairly straightforward, and I've only selected 1 case each to demonstrate those because they are very, very easy to understand. They're very straightforward. And the 3rd category is a bit more difficult, and we will look at a number of cases, including Leaf and International Galleries, which we'll come back to in a few moments. But let's deal with the easy ones first. So the first type of common mistake that we're going to look at is res extincta. Now that's Latin, and that literally means that the thing does not exist. Now, what happens when you buy something or when you have a transaction about something which does not exist? Well, generally speaking, what happens is that that transaction is void. A good case to demonstrate this is Courtier and Hasty. This was a case about buying corn which was being shipped from Greece to England, and the transaction took place while the shipment was in transit. What was not known to both the buyer and the seller was that the corn had gone off. It was no longer in existence. What had happened was that the corn had gone off, and the captain of the ship had sold it to someone else just to get rid of it. So at the time of the contract, there was no corn to be sold. And the court said that meant that this was a situation of res extincta. The thing that the contract was about did not exist, and therefore the contract is void. Now, as you can see, timing is of crucial importance. If at the time of forming the contract, the corn had still existed, but it had gone off 5 minutes later, or 5 hours later, or 5 days later, the contract would have stood. However, since the corn had gone off before the contract was formed, the contract did not stand. So that's the area of res extincta, which is one of the 3 subcategories of common mistake. The second easy one is res sua. Res sua literally means the thing is his. This is a situation where there is a transaction involving something that is passed from one person to the other. However, the person who purportedly buys that something already owns it. And so obviously you can't have a situation where someone buys something that they already own. And so these kinds of situations, those kinds of contracts are void for common mistake because of res sua, because the thing is already his. A good case to demonstrate this is Cooper and Phibbs. Cooper and Phibbs was a case about a fishery which was owned by someone, or supposedly owned by someone, an uncle. And when the uncle passed, the aunt, who supposedly inherited the fishery, leased it to her nephew. And the nephew paid money. Now, as it turned out, the uncle, when he died, had bequeathed the fishery to his nephew. So at the time that the aunt and the nephew made their contract for the lease of the fishery, the nephew already owned it. So in other words, the nephew was leasing something that he already owned. And that makes no sense. And so the court said, well, that contract is void because of res sua. The thing was already his. The nephew already owned it. And you can't go and buy something or lease something which you already own. So those two subcategories of common mistake, res extincta, res sua, very straightforward, very simple, not a lot of difficulty in applying those principles to other situations. However, there's a third type of common mistake which does not have a nice, neat Latin name. It's probably the best way of describing it is mistake or common mistake as to quality of the subject matter. The leading case within this third category of common mistake as to subject matter or common mistake as to quality of the subject matter, is Bell and Lever Brothers. Bell and Lever Brothers was a case about an employee, a manager, who worked for Lever Brothers. Now, he had a contract, a long-term employment contract, which was not terminable. However, Lever Brothers merged with another firm, and the services of Bell were no longer needed because his position had become redundant. And so the parties had to find a way of compensating Bell to basically buy him out of his employment contract. In the end, Lever Brothers agreed to pay Bell a large sum of money, basically to undo the previous contract, the employment contract. So we have the employment contract, and then we have a subsequent contract, which is to dissolve, or the purpose of which was to dissolve the initial contract. And Bell received a lot of money. However, soon after that, Lever Brothers found out that they could have fired Bell on the spot without paying him any money, so they refused to pay. And the reason why they could have done that is because Bell had breached some of his duties as a manager while he was still in their employment. And so Lever Brothers refused to pay and Bell sued. The court held that although this might seem to be a situation of a common mistake, in fact, the quality of the subject matter had not changed, and so the contract stood and Bell was entitled to his payment. So let's try and break that down a bit. Bell and Lever Brothers, imagine, are sitting in a room negotiating the dissolution of the employment contract. And Lever Brothers offer him some money and he accepts, and so they agree to dissolve the employment contract. Lever Brothers are doing this in the belief that this is the only way that they can basically get rid of him. Bell believes that he is entitled to that money for the dissolution of his employment contract. So they both have that belief. But in the background, unbeknownst to Lever Brothers and unbeknownst to Bell, at least at the time of negotiating, it was not, as the jury found, on his mind. It was not part of what he was thinking about, is the fact that Bell breached his fiduciary duties. So the common mistake by both parties that is common to them is that they thought they were negotiating about the dissolution of an employment contract, and they were not aware that this employment contract could have been dissolved in another way, namely firing Bell on the spot. So that in a nutshell is why there's a common mistake here, and the court found that the common mistake is not of a nature that would lead this contract to be voided, because the court argued that the quality of the subject matter remained unchanged. The fact that Bell got more money, or he got money, whereas if he'd been fired, he wouldn't have gotten any money, doesn't change the essential quality of the subject matter, namely dissolution of the employment contract. That was really what the whole deal was about.